everyone, this is Elizabeth Polinsky, licensed clinical social worker and marriage counselor in Norfolk, Virginia. And today I'm going to talk a little bit about the process of divorce because it is really confusing for a lot of people. And part of that is I'm going to talk about kind of just generally the process of divorce in different states, and then specifically I'm going to talk about it in Virginia since that's where I live. And I'll talk a little bit about child custody and what that means and what that looks like. And then I'm going to end on some information for other therapists and clinicians, specifically about information for how to conduct child custody evaluations and some things that are important for therapists to know, as well as some recommendations for when a therapist gets a subpoena from a court and releasing information. So we're going to cover a lot today. So I have some notes that I'm going to be following and looking down. But let's just start off with how marriage and family therapy, or any type of therapist, as long as they're a licensed, qualified professional, could be of assistance during a divorce process. So divorce is oftentimes there's at least one partner that doesn't want it, and many times both partners don't want divorce, but they don't know how to fix the relationship. So and then there are some instances where both partners in the couple have decided that they do want divorce. So there's kind of a broad range there, but especially when it's one partner who doesn't want a divorce, there can be a lot of conflict. Even if both partners do want divorce, maybe they both want divorce because there have been lots of conflicts leading up to their decision. And this can be problematic for kids. It's really important that as you go through a divorce process that you keep the conflict down to a minimum. That is going to be really helpful, especially if you have kids. So kids can be impacted by sort of like shouting and name calling and like louder fights between parents, but they can also be impacted by things like the silent treatment. That impacts them too. Kids can pick up on it. What is especially harmful for kids is if you put them in the middle between two parents. So sometimes that looks like telling your kid to tell the other parent something, or asking your kids information about, what's your mom been doing, what's your dad been doing, who have they been hanging out with. Anything like that puts your kid in the middle and puts them in a really, I think it's probably an awkward place to be, even if it was like your friend. And it's so much more stressful for kids, and it can be harmful. So putting them in the middle, having them carry message, grilling them about your ex-partner's whereabouts and details about their life. Also putting your previous partner down in front of them. So if you say things like, "Oh, well, clearly your mom doesn't love you because she's destroying our family," that's going to be harmful for your kids. Anything in that realm. And when kids are put in positions like this, it increases their risk of depression, it increases their risk of alcohol or drug use, and then they tend to have more poor social and academic skills and functioning. So really, really important to keep conflict to a minimum during a divorce process. So there are 4 options when you are going through a divorce. I'll say this is where I'll maybe tie in the state of Virginia. So in the state of Virginia, there can be a fault or a no-fault divorce. A no-fault divorce is when you're saying, like, we just have these differences, we can't figure out how to fix them, we both agree that divorce is the best option, we're agreeing to the divorce. So we're kind of legally saying we're on the same page and no one's at fault. It is what it is, and we're gonna collaborate together to go about getting divorced. When you do this in Virginia, there are 2 stipulations. So if you have kids who are under 18, then you have to be separated, living separately for a year, and have a signed formal legal separation agreement before you can file for a divorce. If you don't have the separation agreement, or if it hasn't been a year, then the courts will throw it out. The other thing, so that's if you have kids under 18. If you have kids but they're grown up, they're out of the house, they're over 18, or you've never had kids, then you have to be legally separated for, sorry, let me take that back. You have to be living separately and have a signed separation agreement, but the length of the physical separation is only 6 months instead of a year. Now, if you are going the route of a no-fault divorce, you have some options. Mediation is a really great option. That's where you have kind of like a neutral third party who is there to help you come to agreements about how you might want to co-parent, how you want to split up property and financial things. So that's the 2 of you and a neutral third party to help facilitate those discussions. The second option is called a collaborative divorce. And this is where, let's say I have an attorney and my partner has an attorney, and we all, the 4 of us, agree to sign a form that says we are going to try to come to an agreement, the 4 of us, and to keep things out of the court. And should the situation not be resolvable among the 4 of us, or the 4 of us can't come to an agreement and we end up in court, then my lawyer and my partner's lawyer, they're out. We can't use them. We have to get a new lawyer. So this is kind of similar to mediation, except that the lawyers are there. So instead of having one neutral person, I have someone kind of on my side and they have someone kind of on their side, and they're all helping us navigate these conversations. Sometimes you could have this situation where with the 2 lawyers and the partners, and also have a mediator or someone else who, like a marriage and family therapist, who might come in to assist with conversations. There's also co-parent counseling. So I'm going to just cover this real fast, although this may not be the best section to cover it. Co-parenting counseling is kind of like family therapy and is often done by a marriage and family therapist or another therapist who specializes in couple and family functioning. And co-parenting counseling is for if you have kind of sorted out a lot of the other things, like the focus isn't on how are we going to decide who gets the house and who gets, the vacation rental type of thing. Instead, the focus is on, let's come to an agreement on how we want to co-parent our kids. What are the goals that we have? How do we make sure our kids are doing the best that they can, given that we are separating and we're going to be forming a totally different type of family. For cases where there has been a lot of fighting, a lot of escalation, and the 2 people, they just cannot come to an agreement on co-parenting, then there is something called parenting coordination, where it may be someone who's a licensed therapist, or it may be someone else who can kind of act as a go-between between the 2 partners, or in this case, ex-partners, to help smooth the discussions around parenting between the 2 parents. So that would be if there's just so much tension between the two parents that it's just not going to be feasible to have a productive conversation together, then you could have somebody who is kind of a go-between between the two of you, as long as it's not your kids. So backtracking a little bit, so we talked about no-fault divorces, and then in Virginia you also have a fault-based divorce. And a fault-based divorce can be filed immediately. So, you do not have to wait 6 months or a year. You can do it right away. The thing is it could be contested. So basically, if I am saying I want out of this marriage because my partner messed up and they're at fault and they're the reason why this marriage is ending, then I'm kind of, in a way, I'm accusing them. They're the ones at fault, and I can do that right away. And reasons that I could do that are, let's see, I have this written down somewhere. Adultery, cruelty, desertion. So if they've just kind of up and left and they've been gone and I haven't seen them for the past few years, and I can just say, hey, my partner deserted me. And a felony conviction. And I'll say that cruelty in this case includes instances of violence in the relationship. So if there is any intimate partner violence, you could use that to say, no, my partner's at fault, I'm leaving because they've been cruel to me, and you could file right away. Now your partner can contest that and they can say, no, I'm not at fault. And this is where the legal side can get more ugly and kind of rougher emotionally. Not that divorce is, really ever easy, but it could get more ugly when we've got this accusing, defending, accusing back thing that happens in the courts. So now if you file a you're at fault type of my mind is going blank. If you are trying to get a divorce saying your partner is at fault, they could say, no, I'm not. And they could do a couple of things to state that. So they could say that whatever they did was justified because of whatever you did. They could say that, well, actually we had an agreement. So for example, if you all agreed that you could be non-monogamous and then you were trying to say, oh, well, my partner cheated on me, they would say, we agreed to be non-monogamous, and then the court would throw it out. So those are some. The other one is if you have forgiven your partner. So let's say that several years ago somebody cheated and you all worked through it and you forgave your partner and you kind of moved on from that. You can't use that now to try to get a divorce faster. So now that is all about the divorce. Let me switch over and talk about child custody. So in an ideal world, if you can do a no-fault divorce where everything gets agreed upon, then child custody is something that you guys agree upon, either through mediation or through collaborative divorce processes. So it's really only when there's an at-fault type of divorce where child custody gets decided by the courts. Custody gets decided, visitation gets decided, and sometimes like how kids are raised. I think what gets really common is when people move. So maybe you all have agreed to everything, and then 5 years down the road somebody wants to move across the country. Then this might come back up in a court case again, and the courts might help you guys, or may make a unilateral decision about what's going to happen in the interest of the child. Now, if there is a fault divorce, or if we're talking about child custody when someone is trying to break the original agreement that was made around child custody, the courts can ask for a child custody evaluation, and this is often performed by a mental health professional who is specifically trained in forensic evaluations. So there's a very big difference between a forensic evaluation that's done by a mental health professional and receiving therapy and counseling services, and this should not overlap. And in fact, we would say it's not allowed to, and it's unethical for your therapist to also act as the forensic evaluator. So let's see, let me just check my notes. So I guess it is important to note that like 90% of cases are able to just kind of agree on the custody arrangement on their own, and they often don't need an evaluation. It's only when parents can't agree and that the courts come into play, and then they ask for an evaluation. So so this is where I'm going to switch over to information for specifically clinicians who are going to be doing forensic assessments, but it's good information for everybody. So the thing is that the clinician needs to have demonstrated competence in forensic evaluations and have a history of adhering to the code of ethics. And when they're doing the evaluation, they have to maintain the focus on the child. So they're going to stay out of any conflicts and fights between the two parents. The evaluation tends to focus on parenting attributes such as skills, deficits like challenges that they have in parenting, values and tendencies. They'll also take into consideration, like, are there other caregivers like a mom or an aunt, a grandma who might be involved in it and in parenting the child. But overall, okay, so then they'll be evaluating the parents and then the child's psychological needs and how that fits with each parent. Really, they have to stay impartial, and they're trying to stay very neutral among everyone to really work in the service of the child and make sure that the child is put in the best place that they can be put in terms of placing and for custody. So things that a clinician needs to be thinking about in terms of the code of ethics for forensic evaluations has to do with non-discrimination, so really understanding cultural bias and doing a lot of like self-reflection and making sure personal values aren't playing a role in how they're interpreting data. They need informed consent. So you should be able to explain to the family how the type of data that you're collecting, maybe how the information is going to be used, what it means with the court. So you have to make sure that they agree to being evaluated, even though the court is ordering it. You'll still need a release of information. You'll need to disclose the limits of confidentiality. You still have to protect the records and maintain the records over a period of time, and that varies by state. And avoiding professional opinions about people that haven't been interviewed by you, and just generally kind of making sure that your testimony is accurate, objective, fair, and independent. Now, sometimes, so that's if you're a forensic evaluator. Now, sometimes a marriage and family therapist or a clinical social worker or another mental health clinician will get subpoenaed for records, even though they're not the forensic evaluator. Records for a therapist are going to be really different because the focus is on helping someone achieve their goals in therapy and is not related to child custody at all. But sometimes you get subpoenaed. So generally, you can respond back. So you might get, well, let me just start off. You might get subpoenaed by an attorney, or you might get subpoenaed directly from the court. So regardless, you have to respond back, but you can respond back and just say, hey, I have client therapist privilege, and I can't just release this information to you. So push back a little bit when you get a subpoena, and then the courts will have to decide, well, is it actually protected? They could come back and say, we don't care what you think, give us the records. And at that point, you give the absolute minimum that they're requiring. And if you have any questions about this, you want to always consult your attorney, especially because there are some unique cases, like if they have been the victim of a crime, or if it's the FBI giving you a subpoena requesting the information. The Patriot Act has some like unique things where you kind of have to like give them stuff. So when in doubt, contact your attorney, and when in doubt, push back and say, hey, I have privilege. This is privileged information. I don't have to share it until they kind of force you to share it. And when you are forced to share it, give them the minimum necessary, and try to get a written authorization from the client. And that also kind of varies by state, but to be the safest, most ethical clinician you can be, you always want a written authorization to release the information, even if you were subpoenaed. So you can still request it, and then if for some reason the client refuses, you just document that in the chart. So I hope this information was helpful. I am realizing the time. I have so many more notes about this process. So if you have questions or concerns, you can contact me. But this video is already 22 minutes long, so I think that will have to suffice for a quick intro into how the divorce process works and how a clinician can be involved in helping with that process. So I hope you liked this video. If you did, please like it and subscribe to my channel, and make sure to comment below. I'd love to know your thoughts and even your experiences with working with evaluators or going through the divorce process, or if you have information about how it varies for your state. So yeah, have a great day.